Law is the foundation of everything that we do in the criminal justice system. It creates the parameters under which we operate, the procedures that we use to fulfill our jobs and responsibility to the community, and defines when a person has done something illegal that should come to the attention of the criminal justice system. Law also gives us power in the criminal justice system. When we interact with someone on the street, whether it be a community member or a suspect, someone in our court systems, or an offender in our correctional institutions, we represent all of society through the legal system and the laws that we represent. And so when we arrest an offender, we're not arresting them personally. We're representing the people. The last thing you want to do in the field of criminal justice is to run into someone who's a suspect or an offender who knows the law better than you do, because that can give them the upper hand and leave you in an embarrassing situation as a criminal justice practitioner. It can destroy your reputation with other members of the criminal justice field, such as judges and prosecutors, and reflect badly overall on yourself, your department, and the entire criminal justice field. There are essentially two distinct categories of legal action that can be brought against an individual. The first is a civil case. A civil case means that you have harmed me in some way, and so I'm going to take you to court, show that you wronged me, show that you caused me this harm, so that I can get restitution and maybe some punitive damages. The level of proof needed to prove my case in a civil court is beyond the preponderance of the evidence. So 51% sure that you did it. I just have to prove this more likely than not, that you committed the action and that action caused me the harm that I'm saying that you caused. In a criminal court, it's society prosecuting an individual for a breach of the laws that were created by the society in which they're in. So in other words, if you assault me, you're assaulting me personally. I can take it to civil court, but I can also take it to criminal court because that's a violation of a law within the community and society that I live in, and so all of society has a stake in seeing that you're punished and dealt with for violating that law. Now, a successful prosecution in criminal law requires proof beyond a reasonable doubt. And what that basically means is that you're 99.9% sure this person committed this crime and caused me the harm that I'm saying was caused. And so that's a bigger standard. And so sometimes what you'll see is somebody get proven innocent or a case get acquitted in criminal court, and then they lose a case against a defendant or a family member of a defendant in civil case. And that's because the standards of proof are so different. So where does all this criminal law come from? Where does all this procedural law come from? The highest ranking legal document in our country is the U.S. Constitution. All laws have to conform to the constraints and the parameters set forth by the U.S. Constitution and cannot infringe upon the rights that are explicitly given to individuals in the United States within the Constitution's amendment. And so when a law is passed, if it doesn't conform to the restraints or the protections described by the U.S. Constitution, then it can be appealed in federal court, and if the court finds that in fact it does violate some constitutional provision, that law can be determined null and void. States also have their own constitutions that sometimes provide additional rights to individual citizens within that. Statutes, these are laws passed by legislatures and approved by executive branches or passed with a veto-proof majority. Ordinances are laws passed by your local government. They can be things like leash laws or youth curfew laws or things like that. Administrative law is laws passed by governmental bodies that don't have to go through the traditional legislative process. So, for example, the EPA can pass administrative laws that regulate certain activities related to environmental protection. Case law basically means that courts look at past legal decisions when making future decisions about the legal process and about laws that are on the books. So, for instance, if you appeal to the Supreme Court and say that one of your constitutional rights are violated, the Supreme Court is going to look at past legal history and what the court has said in the past about the parameters under which that particular right has been interpreted. And they're going to use that to inform their decision going forward. That doesn't mean that they have to stick and agree with whatever that decision was, but it provides a basis on which they can build legal precedents. Now, there are circumstances where you can engage in a behavior that is criminal, but not be responsible or held liable for that behavior. These are some of the conditions under which that can happen. Under duress, I committed a criminal action, but I was forced to do it. Someone was holding a gun to my head, and made me take money out of this ATM. For over 100 years now, we've had a juvenile justice system within the criminal justice system as a whole. The idea is that people underage are at a diminished capacity to regulate their behavior, to understand wrongfulness of their actions, and to engage in impulse control. Today we have brain imaging to back that up, because now we know that the brain isn't fully developed in the prefrontal cortical area, which is key to impulse control and higher thinking, until the mid-early 20s. And so we don't hold juveniles to the same standards that we hold adults. For instance, the Supreme Court has ruled that we can no longer sentence juveniles to death for crimes they may have committed while they were underage. Self-defense, there was no other way out. A person broke into my house, they were pulling a gun, they were about to shoot me or my family member, and I shot them first. Yes, I committed a homicide. Homicide just means that one person killed another person. It can be during war, it can be you work for a correctional department and you're the person that does the executions. Whatever the reason, homicide means one person killed another person. In this case, I committed the homicide, but there was a justifiable cause that alleviates my criminal responsibility. I had to shoot him to protect myself and my loved ones. Entrapment, the police can't trick you into doing something you wouldn't ordinarily do. So, for instance, if I, as a police officer, walk up to you and I, for 6 months, try to get you to take these drugs over to this other house and sell them or get an envelope to bring back to me, and after 6 months of pressuring you into this, you finally say, all right, fine, I'll go do it. And then I wait on you across state lines to arrest you as soon as you go over there to deliver those drugs. That would be entrapment, because you had to really work to get me to do it. It wasn't something I ordinarily do, and you did it just basically so that you could arrest me. The first question that comes to people's mind is, well, what about drug buys? A police officer goes in the community, finds somebody, buys drugs off of them, and then arrests them. Isn't that entrapment? The answer is no, and the reason it's no is because I'm not asking that person to engage in any behavior they don't ordinarily engage in. So, for instance, a police officer comes to me tomorrow and asks to buy drugs. Now, I don't sell drugs, I don't use drugs, I wouldn't know where to get drugs right offhand. It's not a behavior I usually engage in, so I'm not going to be able to sell him any drugs. Now, if he goes into the community and goes to a known drug dealer and he buys drugs, and the drug dealer readily gives him drugs or can get a hold of them in a little bit of time and get him the drugs he's wanting, then that shows that this is probably a behavior he regularly engages in. This isn't difficult for him. And so it's not entrapment. He's just caught him doing something he usually does. Another example that gets brought up a lot of times is, what about a police officer waiting in the bushes and then you speed by and he comes and gives you a ticket? I mean, there he is waiting to catch you. Isn't that entrapment? Well, no, because if I don't usually speed, then I'm probably not going to be speeding when I drive down this road and don't see a police car. Now, if I drive down speeding, that's probably behavior I usually engage in. He's just catching me do something that I ordinarily do anyway. Necessity basically means, yes, I committed this crime, but I had to. If I didn't commit this crime, a larger crime would have resulted. Insanity essentially means that at the time of the commission of my crime, I did not understand the wrongfulness of my actions or the impact that my actions were going to have on myself, the victim, or society as a whole. So, for instance, I can have a severe mental health issue. I can be a paranoid schizophrenic with extreme bipolar disorder and a whole bunch of other problems. And that's still not enough to define me as insane. Because remember, insanity is not a psychological diagnosis. There's no psychological or psychiatric term for insanity. It's purely legal. And it just means that whatever conditions you were suffering from, you had an instance where they compromised your thinking so much that you were not able to understand the wrongfulness of your actions or the impact they were going to have. Now, just because you prove your insanity defense, that doesn't automatically mean that you're absolved of all responsibility for your criminal action. It can mean that, and that can result in acquittal based on you being found not guilty by reason of insanity. But in many cases, it can lead to a diminished criminal responsibility for your actions. In other words, you are responsible for your criminal actions, but the court recognizes that there was these underlying conditions that may have prevented you from being in full control of your capacities when you committed this crime. So you can be found guilty but mentally ill. In this case, you're found guilty, you're not absolved of all criminal responsibility, but you'll be offered treatment as part of your sentence. And so these inmates will get medical and psychological treatment for their disability while they're incarcerated or serving their time. You can also be found mentally incompetent to stay in trial. Essentially what this means is that at this point in time in your life, you don't understand the wrongfulness of what you did or the impact it's had on yourself, society, or the victim. And so the court holds off your trial until such time as a forensic psychologist can assess you and show that you are, in fact, capable of standing trial and understanding the totality of everything that's going on around you. You can also be found to have diminished capacity. Essentially what this means is the court understands the impact that your mental illness had on your mindset and your ability to impulse control and your thinking at the time you committed the crime, and therefore will take that into consideration and ascribe a lesser punishment for the crime you committed. So in other words, you may be found guilty, but the death penalty is taken off the table. Once you're found guilty and you've had an opportunity to present your evidence for whatever defense that you're going to try to use, the punishment phase kicks into action. And there's several different types of punishments, and these are broad categories under which there's a lot of different punishments a judge can choose. Corporal punishment is no longer available in the United States of America. This is the punishment of individuals through physical pain or torture. Incarceration, this is an American experiment, and before the founding of the Americas, incarceration was basically used as a warehouse for people until their actual punishment was ready to commence. So you'd be put in a dungeon or something until it was time to take you out and beat you or execute you or whatever your punishment would be. Monetary punishment, sometimes they may institute a fine as part of the punishment or some type of restitution where you have to pay back so much of the money that you may have stolen or repair some of the damage that may have been caused by your actions. Community punishments, these would be things like probation, parole, drug court, halfway houses, those types of things. Punishments available in the community so that the offender can serve his sentence in the community, still pay taxes, still take care of obligations with family and all that, but also be watched on to make sure that they follow the rules, they get the treatment that they need, and they're submitting to all the conditions of their community corrections. Now we're going to take a deeper dive look into how the U.S. Constitution, the founding document of our democracy, sets the parameters of how we conduct investigations, what we can and cannot do within the criminal justice system, and how we must uphold the rights of individual citizens. The Fourth Amendment to the U.S. Constitution states, "The right of the people to be secure in their persons, houses, papers, and effects against unreasonable searches and seizures shall not be violated, and no warrant shall issue, but upon probable cause, supported by oath or affirmation, and particularly describing the place to be searched and the persons or things to be seized." What is this amendment actually saying? Well, let's take a deeper dive look. The right of the people to be secure in their persons, houses, papers, and effects against unreasonable searches and seizures shall not be violated. When you think about a person's houses, papers, and effects, you're thinking about their most personal belongings, their personal property, the things most private to them. Our founding fathers were coming from a governmental system where kings and rulers and governments could just come in and search your houses and confiscate your property without any real form of protections against it. And they didn't want that here. They wanted people to be more secure in what they have, protecting against the overreach of government, taking away from free individuals those things which they hold most dear to themselves. And it's only under reasonable circumstances that a warrant shall be issued, and it must be based on probable cause. Down at the bottom we got a little note. Basically, probable cause means enough evidence, if you look at the totality of the circumstances, that would lead a reasonable person to believe that a crime has been committed and this person committed the crime, or that evidence of the crime would be found in this particular location, supported by oath or affirmation, and particularly describing the place to be searched and the persons or things to be seized. Search warrants have to be very particular about where is going to be searched and what property you're looking to seize. So, for instance, if I get a search warrant as a police officer and I go in and I show them all my evidence that led me to my probable cause to believe that you have a big screen TV that was stolen from Walmart last week, maybe there's some surveillance video or whatever, and I get this warrant, I can't then go into your house and start looking through your dresser drawers or small boxes in your closet Because I'm there looking for a big screen TV, and you can't hide a big screen TV in a dresser drawer or in a small box in your closet. And so any evidence I find there would be in violation of someone's constitutional rights. So we have to be very particular about what we're looking for and where it is we're going to find it. Through the years, the U.S. Supreme Court has handed down rulings that have shaped the way in which we determine probable cause. A few of them are listed here. We're not going to go into any detail with any of them. We will in later classes. But again, this is a broad-based overview class. In Bringarter, the court ruled that trustworthy facts would lead a reasonable person to conclude an offense has either been or is being committed. So in other words, I have to look at the totality of the circumstances and come up with enough evidence that would lead a reasonable person to believe that some offense was either going to be or has been committed. In Draper, the court ruled it must be more than suspicion and must be based on evidence. In other words, I can't just go on my gut feeling as a police officer and through my years of experience and say, I know when somebody's doing something and I know he was engaged in some type of problem behavior. That's not good enough to determine probable cause. It must be based on actual tangible evidence. In Spinelli, the court ruled we must verify all information and its sources. For instance, if I'm using an informant, I have to know the reliability of that informant. I can't just go on someone's hearsay evidence. I have to find corroborating evidence that supports the evidence I already have, enough to build it to a point of probable cause. In Illinois versus Gates, the courts basically ruled that this is a common sense area of law. The evidence has to reach a point where a reasonable person using common sense would determine that probable cause exists. Now, it's always best to get a warrant when you can. A warrant creates an opportunity for a third party outside of law enforcement to look at the evidence and say, yes, you have enough to substantiate probable cause. A warrant also provides a certain amount of protection because you did go to that third party who supposedly knows a lot about law, and they said, yes, you in fact do have probable cause to make this arrest or do this search. That doesn't mean you always have to get a warrant, and in truth, you don't always need a warrant or shouldn't get a warrant. Here are some of the exceptions that the courts have carved out that allow police to search and seize evidence and arrest people without a warrant. Plain view doctrine. If I'm somewhere that I'm lawfully able to be as a police officer or as a member of the criminal justice community, and I see evidence right in front of me, I can seize that evidence and make an arrest. So if I'm walking down the street, you're on your porch, and you've got heroin, and you've got needles there, I don't have to go and run and get a warrant. I see that evidence, I can seize it because I had a right to be walking down the street, and it just came into my plain view. Also, if I'm doing a legal search, let's say I'm looking for some drugs, and I have a warrant, and I go in and I look for drugs, and while I'm searching for drugs, I find that big screen TV that was stolen from Walmart. I can seize that and use that as evidence against you as well because I had a legal right to be there. I was executing a legal search warrant, albeit for something else, and this evidence was just in plain view. The open field doctrine essentially says that in open fields you have a lessened expectation of privacy. This includes open fields on your own property. Anybody can look over, anybody can see what's out there. If there's evidence out there to be got, I can go get it. Inventory searches. These are searches not intended to find evidence. These searches are meant to inventory items that are taken into custody. So, for instance, you're driving down the road. The police pull you over. They have your car towed, and it's impounded in the impound lot. The Department of Motor Vehicles has the right to search that car, not looking for evidence, but to inventory your property to make sure you can't come back and say that $15,000 was stolen out of the glove compartment. Now, during this inventory search, if I find evidence, I can use it. Search incident to a lawful arrest. Essentially, if I arrest you, I have a right to search you. This only makes good common sense because I want to make sure you don't have a weapon on you. I want to make sure that you don't have anything to hurt me or hurt yourself. I want to make sure that there's no evidence that's going to be left in my police car. Consent searches. If you give me your consent, I can search you. You can waive any right you have. Automobile searches. The courts have ruled you have a diminished expectation of privacy when you're in your automobile. The reason being is because an automobile isn't stationary like a house. You can take it anywhere you want to take it. And also, there's windows all around so anybody can see into your car and see kind of what's going on. So there's automatically a diminished expectation of privacy. That doesn't mean there's no expectation and police can't just pull you over and just search all willy-nilly. It does mean that you have a less expectation of privacy. Public areas. If evidence is found in a public area where everybody has access to it, I don't have to have probable cause. I can just search that. So if you're sitting at a park bench, you get up, you leave, I can look under the park bench and see if any evidence was left. That's a public area. Everybody has access to it. You have no expectation of privacy. You have some protections if the police illegally search and seize evidence in violation of your constitutional rights. The biggest one is the exclusionary rule. If I, as a police officer, engage in a illegal search and seizure and get evidence of a crime, that evidence cannot be used in court. And beyond that, based on the fruit of the poisonous tree doctrine, any evidence that results from that first original tainted evidence can't be presented in court. So let's say I do an illegal search and I find evidence, but I also find information that lets me know about a big drug deal that's about to go down. And so I use that evidence and I get a warrant and I go make an arrest. I see them exchanging the money. I see the drugs being passed off to the buyer. That evidence is still not good in court because it's based on that original taint of that first violation of constitutional rights. It's always best to get a warrant, but sometimes circumstances are such that getting a warrant would cause the loss of life, harm to individuals, and the destruction of evidence. And here are some of the circumstances under which getting a warrant really wouldn't be a good idea and isn't necessary under the law. People are in immediate danger. If I come up to a door as a police officer and I hear someone yelling for help, I'm not going to go, wait a minute, let me go get a warrant and come back and help you. I'm going to go in, knock the door down, do what I have to do to try to protect and save human life. Getting a warrant would cause a loss of evidence. If this is a case where I know that the evidence isn't going to be there in 15 minutes and I really don't have enough time to get a warrant, then as long as I have probable cause, that's a search that I need to go ahead and conduct. If I'm chasing a suspect, it would be impossible to stop the chase, go get a warrant for his arrest, and then go chase him some more. So if I'm chasing someone who's a suspect and they run into a house or a private area, I can follow them into that area. In Terry versus Ohio, the courts ruled that police have a right to stop someone, questioning them, and do a simple pat-down search of their person to make sure that they're not armed if there is reasonable suspicion to believe that they are in the commission of a crime or doing something that they shouldn't do under the law. We're only looking for weapons in a Terry stop, so we can't go and do a real thorough search of the individual. It's more for the protection of the police officer, the suspect, and any community members that we get whatever weapons they may have away from them while you're in this discussion with them. The courts have ruled that reasonable suspicion does not require the same level of evidence as probable cause. Evidence for reasonable suspicion can include a police officer's background, their experience, their knowledge of crime in a certain area, and the like. Making an arrest also requires probable cause to believe that this person committed the crime that you're arresting them for. That probable cause, again, needs to be based on the totality of the circumstances and based on evidence that is real and that I can show the court. It's always best to get a warrant whenever possible when making an arrest, for the same reason that it's important to get a warrant for a search. It protects the police department and it validates that there was enough evidence to get probable cause. In a misdemeanor arrest, the officer must actually witness the offense that was committed.